I'm Jeffrey Rosen, President and CEO of the National Constitution Center. A few years ago, learning about the forgotten meaning of the pursuit of happiness changed my life. When the founders wrote that famous phrase in the Declaration of Independence, they meant an ongoing commitment to self-improvement and lifelong learning. This discovery inspired me to write a book, and in my new podcast, I explore the founders' lives with the historians who know them best. Plus, filmmaker Ken Burns shares his daily practice of self-reflection. Join me for Pursuit, the Founder's Guide to Happiness. On September 29, 2005, John Roberts was sworn in as Chief Justice of the United States. Hello, friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. This episode of We the People will be guest hosted by Griffin Richie, who's my special assistant at the NCC. Take it away, Griffin.
This week, we will discuss the legacy of the Roberts Court on its 20th anniversary and preview the major cases in the upcoming Supreme Court term. To help us explore these topics, we have two of the leading commentators on the Supreme Court. Sarah Isgur is the editor of SCOTUSblog and an ABC News legal analyst. She hosts the legal podcast Advisory Opinions. Sarah, it is wonderful to welcome you back to We the People.
Thanks for having me.
And Steve Vladeck is a professor of law at the Georgetown University Law Center. He is the author of the New York Times bestselling book, The Shadow Docket: How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic. Steve is also the editor and author of One First, a popular weekly newsletter about the Supreme Court. Steve, it is wonderful to welcome you back to We the People.
Thanks. Great to be back with you.
Steve, let's start with you. You recently wrote an article in your Substack, One First, which discussed the legacy of the Roberts Court on its 20th anniversary. Please tell We the People listeners where you see the court today.
Well, I think to a large degree it stands in the middle of a maelstrom, and a maelstrom that is to some degree of its own making. Whatever the causes and however much one may or may not care about public polling data, there is pretty significant public polling data from Gallup and other entities suggesting that the court is as unpopular as it has been since anyone started measuring that sentiment. And, that's not necessarily in the short term a huge problem for the court. The court is not designed to win popularity contests. But I think it really is quite remarkable to compare the public debate about the Supreme Court, public calls for reforms of the Supreme Court, where we are today in 2025, to where we were when Roberts was confirmed, which was, a court that was much more popular, even notwithstanding its controversial decision in Bush versus Gore, a court that was not nearly so often in the middle of our biggest and most divisive national policy conversations, and a court that was not evenly divided between Democrats and Republicans. There were liberal Republicans on the Supreme Court in 2005, and I think that mattered. So, how much of that is John Roberts' fault versus how much of it is just things that happened under his watch, I think is also a matter of debate. But especially over the last really 16, 18 months, the chief has been in the center of the presidential immunity ruling. He's been in the center of just about all of the big rulings on emergency applications, especially in Trump-related cases since this January. And so I think, the real takeaway is that this is John Roberts' court. And folks will disagree about whether that's a good thing or a bad thing. It is clearly the case, I think, that it's increasingly a court that is under fire, and that fire has both short-term and long-term consequences for the court's ability to do its job.
Thank you for that. And Sarah, what are your thoughts to that thesis about the Roberts Court?
Oh gosh, there's so much to unpack there, per usual with Steve, who's so fun to talk to. Digging into the numbers a little bit, and look, let's be clear, the Chief Justice, I don't think, cares particularly about the approval numbers for approval numbers' sake. As Steve said, right, the court's purpose isn't to be popular. In fact, the court is meant to be counter-majoritarian. If the court was simply there to reflect voters' ideas of what they wanted, we wouldn't need a court. It's like free speech, right? We don't need free speech, the First Amendment to protect the speech we all like. We could just vote on that. you have to have the First Amendment to protect the speech that the majority hates and would want to punish, but for the First Amendment. Same with, criminal justice, due process things. Basically, all the court is there to do is to decide whether something should be left up to the majority. And if so, is it the legislature who gets to reflect that majority, the president who gets to reflect that majority, or is it something to be taken away from the majority by the Constitution? Okay, but here's what's sort of interesting about the approval numbers, and I'm looking specifically at Pew for those who are following along at home. The court's approval was almost as high as it has ever been in 2021, which is kind of crazy. So when we talk about the court's approval number falling, it's not like it's been super consistent or even the times that you'd think. What actually appears to be driving the lower approval numbers is partisanship. Not surprising. So at this point, the court is basically 50% approve, 50% disapprove. And lo and behold, that pretty much reflects our country as a whole. It's because Democratic approval was super high up until about 2021. And then it just fell off the map. Now, Republican approval also used to be incredibly low before that. So Republicans were as low as 33% approve. Now Democrats are at 26% approve. And so I think that's a problem, not so much with the court itself, but with how partisans use the court to make their arguments. They attack the institution because they want it to be majoritarian. Of course they do, right? Anyone in power wants the court to not strike down what they like, to do what they want. What I think is new is using the court as a partisan foil. We saw Barack Obama do it in the run-up to the Obamacare case. We've certainly seen Donald Trump do it. We saw Joe Biden do it. And of course, Donald Trump back at it again. So my thing for the court, if you will, is that John Roberts 20 years ago said he wanted to be like John Marshall. He wanted to have an institution operating as an institution with a singular voice of a multi-member body, fewer separate writings, not overturning, precedent, all of these institutional concerns. But he also said that he looked back at the 17 chief justices and says, you have to believe that most of them have failed. And I wonder whether John Roberts, from that institutional perspective, how he thinks that's going. On the one hand, the court's overturning fewer precedents than ever. On the other hand, it is not a single institutional voice. You're seeing more and more each individual justice speak as their own judicial ideology, more concurrences than ever before, et cetera.
Can I just say really quickly, I don't really follow the notion that it's the court's Democratic critics who want the court to be more majoritarian at a moment when Republicans control both of the political branches of government. I think that actually gives up the ghost a bit, that part of the critique really is institutionalism for institutionalism's sake. But taking a half step back, the point is not that the court should always be counter-majoritarian. The point is that the court preserves its power to be counter-majoritarian in the cases where it needs to be, whether it's the First Amendment cases to which Sarah referred, whether it's cases like the Watergate tapes case, whatever, by otherwise generally being accountable. Paul Freund put it best. The justices should not be making decisions based upon the weather of the day, but they should be sensitive to the climate of the age. And I think part of the problem with the Supreme Court under John Roberts' watch, and again, I think we can debate how much Roberts was a central figure in this development, is that the court has become much less accountable. This is a Chief Justice who refuses to testify before Congress when invited to do so, right? This is a court where Justice Alito in the Wall Street Journal 2 years ago said Congress doesn't have any power to regulate the court, notwithstanding the literal text of Article 3 to the contrary. And so I guess, I just think that we shouldn't think that the court is meant to be counter-majoritarian from sun up to sundown. Part of how the court builds credibility is actually by not being too far out of kilter, is part of by being accountable. And I think it should tell listeners something that people like me, who don't particularly like the folks in control of either political branch right now, are saying that the court should be more democratically accountable, even at this moment when I might not like the specific forms that democratic accountability would take.
I think the way to think about it is that the court is supposed to stand athwart fleeting or bare majorities. and that if you are a huge majority, right, you amend the Constitution. If you're a long-lasting majority, you then use the political branches to appoint justices that agree with your perspective on the court. It's why, when FDR leaves office, all 9 justices shortly thereafter were appointed by Democratic presidents. We got to a point, 1992, where 7 of the 9 were appointed by Republican presidents. The only time it's actually been 5-4 is for this 5-year period in the, 2010-ish area. So I agree with you that it's supposed to be accountable, but it's in the confirmation nomination process that accountability is supposed to happen. And I think that that's how the court is supposed to reflect the political sort of self-governing experiment that we're in. But when I say counter-majoritarian, I don't just mean the court's always supposed to do whatever the opposite of voters want, but that it is not supposed to take that into account when it's making decisions over who gets to decide. And that's why we insulate them so much once they're on the court.
I'll just say really quickly, the notion that democratic accountability stops once the Senate has confirmed a justice and that there's no more interbranch dynamic and that there's no more role for Congress to play once the justices are on the court is not just a deeply modern view of the Supreme Court. It is one that is belied by, most of the court's first 175 years of history. And I'll just say, I think is actually exactly what a lot of people, both on the court and off of it, think today. And to me, that's part of the problem.
But, okay, I'm totally, I don't care or rather, I am fine with the Chief Justice testifying in front of Congress. I don't think anyone thinks Congress actually does real hearings anymore, but let's say they did. And let's say the Chief Justice went and testified. What of it? It's not supposed to change their opinions. So I think we're talking about 2 different things, like the actual substance of what the court does versus going to testify before Congress, or even having an enforceable ethics code through law. I'm fine with that. I don't think it's going to change anything because those are really on disclosure issues. They're not on the stuff that the court actually does and I think is judged on by most people.
So I know we have to move on. I'll just say, I do think that there are ways in which historically the existence of all of these, what we might think of as around the margin levers, whether it was the budget or ethics or controlling the court's docket, or in a couple of cases, all but bribing justices to retire. That was what Congress did to keep the court looking over its shoulder. And I think part of where we are today in the 21st year, celebrating the 20th anniversary of Roberts' tenure, is that the court isn't looking over its shoulder anymore. And I think it should be looking over its shoulder more often. And I think Sarah thinks it shouldn't.
I think Congress should do more in general. So we agree on that.
Amazing. Thank you for that very interesting discussion about the court and its history. I want to now pivot back to something Sarah said about the institutionalist goals of Chief Justice Roberts. We've talked about how Roberts sought to build up the credibility and legitimacy of the court, but he also had this vision of judicial restraint, which is encapsulated in his confirmation hearing, where he said, "We're just calling balls and strikes." Steve, your Substack article argues that the court has failed to really do that in a lot of these big cases during the Roberts Court era. And can you walk us through some of those cases and explain why you believe the Roberts Court has failed to act in a restrained manner?
Well, I really do think that the way to understand why the balls and strikes metaphor was always a tired canard and is especially inapt today is to look at the kinds of cases the court is taking. So the court is taking cases at earlier postures than any of its predecessors ever did. Just to take one example, there's a power the court has to grant something called certiorari before judgment. This is leapfrogging courts of appeals to take a case before it has worked its way through the court system on the merits. Used to be reserved for national emergency level cases, whether it was the Nazi saboteurs during World War II or the steel seizure case during Korea or the Pentagon Papers case or the Iranian hostage crisis case. Once every 5, 6, 10 years, the court would do this. From 2004 to 2019, the court didn't do it once. And since 2019, the court has now granted cert before judgment 23 different times to hop over courts of appeals. Add that to how much more the court is doing on emergency applications. Add that to the number of cases the court's taken these days on appeals of preliminary injunctions as opposed to at the end of cases. And, that doesn't look like an umpire sitting back and waiting for the game to come to him. That looks like a court that is looking out and reaching out to take the cases it wants. In a number of these cases, the court is changing the questions that are presented so that they can answer what they want to answer. That happened in both Dobbs and Bruin, just to take two examples. And so the notion that John Roberts' career and that his behavior over the last 5-10 years reflects broader principles, not just of judicial restraint, but of judicial neutrality, I think is really hard to square with the overall behavior of the court. Now, there are examples within that data set of Roberts dissenting, but those examples are rare. And he really has been in the middle of a court that is willing to decide anything it wants, whenever it wants, without regard to norms that used to really keep the court as a court of last view, not first view.
Thank you for that. And Sarah, what are your thoughts to the Roberts Court as one that is trampling on norms and taking the cases it only wants to hear?
So since the Roberts Court began, 9 out of 10 cases have been decided with at least one of the liberal justices in the majority. And I think it's not that anything Steve said is incorrect. It's just that it's not the full picture. I think you have to juggle with all of it. So yes, there are 6-3 cases along ideological lines. They're actually pretty unusual. Of course, the most likely outcome of any case that gets to the Supreme Court on the merits docket is unanimous. And I found this out the other day. I put in all of the briefs from the last term into my favorite AI model for these sorts of things and asked it to predict the outcome. And of course, it predicted that about 42% of the cases would come out 6-3 along ideological lines as the most likely outcome for any case. It's literally, I thought it was funny it picked that number because that's actually the reverse of the number from that term. It was 42% that were unanimous. The reason that AI is doing that is because it's a large language model that pulls from our coverage of the court. And so when so many pundits are only talking about the 6-3 cases and then defining those as the big cases because they're the divisive cases, our AI large language overlords are going to get this stuff pretty wrong. You look back at last term and there was the God, Guns, and Gays Day where Kagan, Sotomayor, and Jackson each wrote a unanimous decision on a case that conservatives cheered on those topics. And those went into the term as big cases. And of course, once they were unanimous and written by liberals, we never talked about them again. So I think I just wish we looked at the full picture of the court more often. Now, something that I think is absolutely a legitimacy threat for the court or an institutional threat for the court is this rise of the interim docket or the emergency docket and the role that it's playing right now. I think the court is grappling with how to deal with that. I haven't heard a lot of good suggestions for how exactly they're supposed to deal with the fact that you have to have a status quo in the meantime. There's been some on the court who have suggested, well, if the district court and the circuit court both agreed, we should just defer to them. I thought Justice Kavanaugh had a pretty good answer to that. Then what the hell are we doing here? Like, what's our purpose if we're just rubber stamping what the lower courts do? There's the idea that, well, they need more briefing and oral argument on some of these. On the one hand, they are doing more of that, as Steve pointed out. And on the other hand, that takes time too. And so then you're going to need an interim docket to the interim docket to the merits docket. It's like interims all the way down. That's not going to work either. So it's not that I don't think that this area is pretty ripe for criticism right now. It's more that I'm curious what the productive thoughts are and what they should be doing, because all of these come with real trade-offs. And I wish that we could grapple with the trade-offs because, there's 9 people in the arena right now. They're clearly trying to grapple with this the best they can. And they haven't figured it out yet. I think that docket will look very different a year from now than it does today as they sort of come up with the norms for that in a way they haven't had to do before. Because, there's all sorts of reasons that I think we have the rise of this docket. I think that you have presidents doing a whole lot more without Congress, and that would explain some of that beginning rise, the sort of pen and phone Obama, Trump, Biden era. And then I think you have President Trump in particular trying to reimagine, remake the executive branch right now. And that's going to lead to a lot of, okay, well, what should the status quo be? And you have those two storms combining right now at the court, dragging them into all of these political fights. Not good for the institution at all. But I'm willing to give a little bit of grace. Like, these people are doing their jobs under a microscope. Let's give them a few months to figure this out.
Can I say real quickly, I mean, the question was about judicial restraint and balls and strikes, not ideology. And, it's not, I don't know that all of the sort of examples I ticked off of ways in which the court is not acting in a way that's restrained depends upon the court's voting lineup. The Democratic appointees can act in ways that are unrestrained too. I think that's a problem too, not proof that it's not a problem. As for, the emergency docket, I mean, I'll just say two things. First, I actually, wrote a whole book about this that includes some solutions, and maybe we can, read the book and talk about it. But the second point is that this is not new. I mean, the volume of emergency applications from the Trump administration might be new, but the court fundamentally transformed how it handles and how it rules on and how it processes emergency applications 8 years ago. And we've been talking about this for 8 years. And so the notion that, give the justices some time to sort this out, I mean, 8 years is a long time, especially when we're seeing so many cases that are producing such massive statewide and nationwide effects. Seems like the justices should be moving a little faster if that's really what the problem is.
Sarah, what are your thoughts on judicial restraint? What's your reaction to Steve's point that the Roberts Court lacks restraint on the emergency docket?
Yeah, look, when it comes to judicial restraint, this is an argument that goes back to Frankfurter, right? Sort of the OG judicial restraint guy. And he's on the wrong side of Gobitis and then on the wrong side of Barnett, two of our most important First Amendment cases. So, conservatives are the ones who have championed judicial restraint above all things. I just don't think there's many things in the world, judiciary included, where moderation in all things, including moderation, isn't a good thing. As far as the court having 8 years, I think I quibble with it being 8 years of this. It is true that we started to see a rise in nationwide injunctions about 8 years ago, but the court's actual interim docket has really exploded, I would argue, in the first, I guess that is 8 years ago, Steve, in the first Trump administration. Yeah. You go back to 1925 when the court first got control over its docket, and that took quite a long time to work out. 8 years, I know, feels a lot in the Twitter age. It's not actually that long in the age of institutions of, self-governance. That being said, I'm joining the criticism in the sense that, I don't think this is sustainable. I don't think this is a good place for the court to be. I think most of the justices agree with that. There's 9 people, though. It's a multi-member court. It's not up to John Roberts or anyone else to just wave a magic wand and say, here's how we're doing this. They're going to have to work this out, and we're watching them do it in real time. And it's kind of interesting to watch an institution change this way, where we get to see, the tectonic shifts, the evolutionary jump, if you will, happening in real time.
Amazing. Thank you both for that. Now would be a great time to give some closing thoughts on the Roberts Court, both vis-a-vis the emergency docket and on its broader merits trends as well. Steve, starting with you. You mentioned in your article that there are 2 strands of Chief Justice Roberts' jurisprudence, one in which he is acting more restrained and abiding by the goals he set in his confirmation hearing, and another where he is central to the court's rightward jurisprudential shift. What do we make of these 2 different strains, and what do you think about the future of the Roberts Court, given these 2 warring tracks of jurisprudence?
Yeah, I mean, I think, it's hard to look at obvious examples in the last 2 years or so of John Roberts, the institutionalist. And, whether that's a feature or a bug will probably depend upon where you sit. But I don't know that we have examples of the John Roberts who switched his vote and upheld the Affordable Care Act, or the John Roberts who, struck down President Trump's effort to put a citizenship question on the 2020 census, or the John Roberts who, wrote a narrower concurrence in Dobbs and would not have overruled Roe and Casey. Really haven't seen that guy in any of the really, really big high-profile cases of the last 2 years. Does that mean he's gone? I don't know. I think one of the really interesting questions about the term that starts on Monday is whether the, really almost completely one-sided support for the Trump administration that we've seen from the court so far on emergency applications is going to transfer over to the merits cases that are now making their way onto the docket. I mean, we already have, as we're sitting here recording this, 2 very big Trump merits cases that the court's going to hear this term. The tariffs case, which will be argued in November, the slaughter removal of FTC members, overruling Humphrey's executor case that they'll hear in December. It looks like birthright citizenship will probably be back sometime this term. There's a chance alien enemies will come up this term. It's not hard to imagine other cases get into the court on the merits this term. And so I guess, my question is, are we going to see that John Roberts in any of those cases? Because we haven't really seen him yet on the emergency applications. And I think there are enough of those now. I mean, there have been, by my count, 22 rulings by the Supreme Court on Trump emergency applications. That it makes me worry that the sort of John Roberts, the very conservative former executive branch lawyer, is sort of winning the internal battle over John Roberts, the institutionalist. But again, this term, I think, is going to be to a large degree a referendum on that very question.
Sarah, what do you think about the proposition that Roberts has no longer been as restrained in the past few years as he was in the past? And what do you think about this term? Do you think that this term is a referenda on the ability of the court to constrain the president?
So John Roberts was the swing justice there for a few years. And it was a fascinating, I thought, time in the court where you have the chief justice who already comes with some, extra superpowers than the other justices. He can assign the opinion for the majority opinion, for instance. And as we've learned, set the way that oral argument's going to go, although he has hinted that that's been a compromise with some of the other justices and how they want to do it. Then you have the addition of Justice Barrett replacing Justice Ginsburg, and he no longer is the swing vote, right? He is the fourth vote or the sixth vote in a lot of these cases. And, I think we might misunderstand a little bit of what John Roberts is doing. I've sort of described it. It's not a perfect description, and I get that because Steve's going to roll his eyes. But this idea of the 3-3-3 court, that you have Barrett, Kavanaugh, and the chief sitting in the middle, it's not that they're the swing vote necessarily, like that fifth vote in every case in the same way that Justice Kennedy might have been. I think it's more like one of them might be the fifth vote. And the other ones are there, think of it like curling, right? They're the ones with the brooms, like brushing exactly where that heavy stone is going to go, widening or narrowing the aperture of the opinion or moving the opinion in this way or that way. And so I think that John Roberts is actually probably doing a lot more, even when he is the sixth vote, than he would otherwise, and certainly when he's the fourth vote. And again, we're just talking about the cases that are the 15% that are 6-3 or 5-4, the sort of, closely divided cases. The interim docket cases that we've seen so far, I also think can be misunderstood as sort of being a partisan divide among the justices. Many more of them, as Steve will be quick to point out, have been 6-3 than we would see on the merits docket, like a lot more. But I do think that you have to take into account, right, the administrations, Biden and Trump in particular, right, they're choosing which cases they want to ask the Supreme Court to weigh into. So they're far more likely to choose the cases they think they're going to win on. I think the Biden administration was far more likely to pick the cases in which they were trying to find a new executive power, if you will, vis-a-vis Congress. They were trying to creep into the congressional role to let's think eviction moratorium, vaccine mandate, those type of ideas where they wanted to do something big that Congress had not legislated on or had explicitly chosen not to legislate on. The Trump administration is doing different things. First of all, there are a few of those examples, obviously, as Steve has pointed out. The Alien Enemies Act would be probably a good example of that. Birthright citizenship would be a good example of that. But
appropriations.
Well, let me get to that in a second, because I think that's like an in-between. But for instance, many of the individual cases, if we're just talking raw numbers from the Trump administration so far, have been about independent agencies and the accountability that those agencies have to the president. Those are just very different questions legally and as far as where they fall on judicial philosophy and what one thinks of the administrative state and the accountability it needs to have within the executive branch and who these people actually report to. And so you're going to see that divide along 6-3 when so many of the cases are on basically the same question. The impoundment question that Steve just raised is interesting because it's somewhere in between for me if we think of these on a spectrum. The impoundment is clearly not the same as the accountability that someone who works in the executive branch might have to the president or to someone. But it's also not the same as the idea that Congress passed a law a long time ago and we're trying to find we want to do this thing that wasn't explicitly like contemplated at the time, but maybe Congress meant to give us broader power, tariffs being like the super obvious Trump example of that. The idea that Congress says spend this money and then the president's supposed to execute spending that money is tough because no president can spend all of the money exactly that way. There's a lot of deference put in there. So impoundment has been this long-running thing since the Nixon administration, and certainly even before that, again, it doesn't fall perfectly into either camp or the other. And I think that the court will have to grapple with impoundment, as we've known since Trump took office, that was coming down the pike.
Thank you both for that. And I think you both teed up the connection between the legacy of the Roberts Court and some of these current cases and what we can see more generally with that. So you've mentioned how the broad endorsement of the unitary executive theory and a muscular understanding of executive power more generally has occurred in some of these recent emergency docket cases. And we're going to start seeing these cases on the merits docket. So Steve, starting with you, if you could just walk us through some of those cases that you think will be these referenda on the court and their relationship to the Trump administration. Let's start with the tariffs case. Can you give a little bit of background on that case and where do you think the court will come down given some of their past decisions on the major questions doctrine?
I can try. So the tariffs case has the privilege or dubious distinction of being the first of these cases to get to the court on the merits. I think it's worth underscoring a point that we don't spend nearly enough time talking about that Sarah alluded to already, which is the government chose for this to be the first case that got to the court on the merits. That's for a reason, right? There's a reason why the government is slow walking the alien enemies case by seeking rehearing en banc in the Fifth Circuit rather than going to the Supreme Court. And so, the notion, this is also why I think Sarah and I have a long-running disagreement about how much we should pay attention to the overall number of divided versus unanimous opinions, because there's a lot of strategic behavior by the parties in choosing when to bring cases to the court and by the justices in choosing which cases to take. All of that said, I think the tariffs case is a close call. The question is about whether this 1977 statute, the International Emergency Economic Powers Act, delegates to the president the power to impose the tariffs that President Trump has imposed. The statute says not a word about tariffs. It has never been used until this year as a statutory basis for imposing tariffs. And those 2 points all by themselves were actually pretty central to the court's analysis 2 years ago in Biden versus Nebraska and explaining why the HEROES Act of 2003 did not authorize President Biden to promulgate his student loan debt forgiveness program. I think the court is going to have a little bit of difficulty, even if it wants to uphold the tariffs, trying to explain why this statute that's been on the books for 48 years and never used this way and doesn't have any of the clear language that the court demanded in the student loan case is somehow different. That said, right, the court has gotten out of tighter boxes before, whether persuasively or not. And so, I think it says quite a lot that the Trump administration was willing to hustle so quickly to get this case to the Supreme Court, even faster than the federal circuit had tried to force it to take the case to the Supreme Court. Because I think that the Solicitor General believes of all of these cases, save the unitary executive removal cases, of all of the merits cases, of all of the substantive legal authority cases, this is probably the one about which they're the most confident. Doesn't mean they're going to win, but I think it's the closest. Assuming birthright citizenship gets to the court this term, I think the government's going to lose those cases. I don't think it's going to be close. But I also think the government thinks it's going to lose those cases. And a good example of that is that in one of the two cases the government's taking up, the dissenting opinion in the Ninth Circuit in Washington versus Trump was all about why Judge Bumate didn't think that the state of Washington has standing. The government's not asking the court to review that part of the Ninth Circuit's decision. Usually we would expect the Solicitor General to, harp upon any ground on which the government might prevail. And so, I think the problem is that by the time this term is over, the Trump administration is going to have won some of these cases and it's going to have lost at least one of them. But the real question is what happens in the interim? I mean, the real question to me is not just these 3, 4, 5 high-profile merits cases we get this term, but the continuing flood. And let's be clear, it is going to be a continuing flood of emergency applications that's going to happen as the Trump administration keeps trying to do what, at least to my view, is clearly unlawful things, whether it's in the context of punishing political opponents, of trying to prosecute political enemies, of deploying troops onto the streets of American cities, and federal district courts across the country are going to push back. And so, I think part of the problem is that we are so inclined, especially in the sort of the days and weeks leading up to the first Monday in October, to look at the merits docket as the sine qua non of what the Supreme Court is going to do that's important in the next 9 months. And I actually think that the emergency docket is going to continue to be just as important, and the court's behavior is going to continue to be just as meaningful. And I fear that, Sarah's point, with which I completely agree, that for whatever reason on the emergency docket, we're seeing more sharp ideological splits, that's going to persist.
Thank you for that. And Sarah, you talk about on your podcast, Advisory Opinions, the difference between the Gorsuch view of the major questions doctrine and the Barrett view of the major questions doctrine. Please walk us through those different understandings, why they could be relevant in the tariffs case. And then please also address, if this is not too much of a 3-part question, the claim that the merits docket may not even be as important vis-a-vis the emergency docket once we start to hear some of these major cases.
Yeah, okay. So first of all, totally agree with Steve that the court is going to have a very hard time distinguishing the difference between Biden v. Nebraska, the student loan debt forgiveness case, and how they decided that one from the tariffs case. Even though there are some distinctions, for instance, this is in a foreign policy context, and there's some argument that the major questions doctrine wasn't ever really meant to apply in a foreign policy context where you might expect Congress to give broader discretion maybe to the president. This is an argument that Jack Goldsmith from Harvard Law has made. That may be true, but it is simply not true enough, if that makes sense. And I think the fact that they took 2 cases, one was ripe from the federal circuit. One, as Steve alluded to, was actually just from the district court. And this gets a little bit into the weeds, but the reason I think they took that case from the district court is because in order to get to the federal circuit, it has to be a law about tariffs. And if they were to hold that this law isn't about tariffs, they would lose in some ways jurisdiction over that case. And so the reason that you take the second case is because you intend to say that the statute isn't about tariffs, but you need a case that then can continue on once you've said that to say, therefore, the tariffs are unlawfully done. So I think there's a lot of reasons to think that the administration loses that case, whether they think so or not. That being said, I think Steve's right that it's the one that they're most confident on, other than the Federal Trade Commission type independent agency case. But being most confident with a bunch of losing cards isn't necessarily the best thing in the world. Okay, major questions doctrine. Gorsuch thinks that this is more like constitutional avoidance. It's a thumb on the scale. It's meant to come to a outcome that may not be the best reading, but it is a reasonable, plausible reading that also avoids this, you want to call it a non-delegation problem, or just a forcing Congress to do its job problem. So the Gorsuch version would be, it doesn't even need to be the best reading, but it's a good reading, and we want Congress to be as explicit as possible. We don't want the president just running wild, doing all the things. And especially in the tariff case, this Gorsuch version is really bad for them, because if you believe that the president can institute worldwide tariffs due to a national emergency of trade deficit, then all of a sudden IEEPA might have just handed over all legislative power to the president. And we no longer need Congress to pass any laws. So they really don't do well under the Gorsuch version. Under the Barrett version, Barrett thinks of the major questions doctrine as a way to more clearly read the statute. It's just unlikely that Congress would have written it this way if they were intending to give all this power. So in that sense, it's more of a textualist tool in the toolbox. Again, I still think that the Trump administration loses under this version of it, but it's at least a better version for their arguments than the sort of strong form major questions doctrine of the Gorsuchian school. That's a word I'm making up today? You also, of course, have the more consequentialist justices, where they actually care sort of what chaos comes from this. I'll put this out there because this is a nerd podcast. And so I think the nerds will appreciate this. There is another problem lurking in the tariffs case. If they strike down the tariffs, what happens to all the people who paid tariffs and how do they get their money back? And so I think you could see from the consequentialists something, bend yourself into pretzels, and the Chief Justice, pulls a rabbit out of the hat and says, for a variety of legal reasons, there's no refunds coming. So basically from this point forward, the tariffs are unlawful, but we're not doing retroactive. It was only 6 months or whatever. And sorry, you paid some tariffs and we're moving on with our lives. Gorsuch is my more YOLO justice. He does not care about the consequences. He doesn't care if there's then thousands of cases flooding the Court of International Trade saying, where's my money? I want my money back. So I think that could also just be an interesting split on the court. Again, there's 3 splits going on. There's the real merits, are the tariffs lawful? There's the major questions doctrine split. Oh, I'll come up with another split over this idea of which court had jurisdiction, and then another split over whether you get refunds. So even though I think Steve and I are in agreement over the administration probably losing this case and the tariffs being struck down, boy, there's a lot more here that legal nerds are going to be, getting, chewing on, getting real full on. It's a 5-course dinner.
Now, let's pivot to another major executive power case that you both have brought up in passing. I'd love to do a deeper dive into Trump v. Slaughter, the case where the court seems poised to overturn the longstanding precedent Humphrey's executor. Sarah, can you walk us through the potential impacts of that case and discuss how the second question presented specifically could have broad implications?
So this is a case about those independent agencies. Humphrey's executor, of course, goes back to 1935. Also about the Federal Trade Commission. That's what kind of makes this case fun. You have 90 years apart Federal Trade Commission. One of the original arguments from the administration was that the Federal Trade Commission of 1935 may have the same name as the current Federal Trade Commission, but does very, very different stuff, and that they don't need to necessarily overturn Humphrey's executor that validated the structure of the Federal Trade Commission and the only for cause removal powers of the president, because this Federal Trade Commission is so different. In the end, I think the court wasn't that interested in parsing between those different Federal Trade Commissions, such as they are. You can go back and look at then Judge Kavanaugh's writings on the matter. And he said, Humphrey's executor, as the law said that, this is constitutional, but constitutional is not always wise, he wrote. And he went through this example of John McCain calling for the firing of the SEC chairman. This was in the wake of the 2008 financial crisis. And John McCain, of course, backs off of it when someone pointed out he had no power to fire the SEC chairman. Reading here from Kavanaugh. But was Senator McCain's suggestion so unthinkable? Let us assume for a minute that the chair of the independent agency has exercised his or her rulemaking or enforcement authority in a way that is ethically and legally permissible, but simply turns out to be unwise and causes great harm. Should that official be subject to removal? What if the agency head is mediocre or just average at his or her job? Normally, persons exercising tremendous executive power and responsibility are not insulated from direction, supervision, and ultimately, if necessary, dismissal, either by elected officials or the people themselves. Why shouldn't someone have the authority to fire such persons at will? And if anyone is to possess that power, it must be the president. When president candidates crisscross the country for 2 years, engage in endless town halls, speeches, and debates, the people expect that the leader they elect will actually have the authority to execute the laws as prescribed by the Constitution. But he goes on to explain how that's not the way it works in large sectors of American and domestic policy. This is a long-running issue within conservatism, right? This idea of the unitary executive, that all powers derive from the president, and therefore the president must be able to fire these people at independent agencies. They have noted that the Federal Reserve may be different. That case, which Steve didn't list, but I think is also teed up to come because they've taken this case. I think that it's pretty clear that Humphreys, it's named Humphreys Executor, by the way, because Humphreys died. And so his estate is the one that brought that lawsuit in 1935. I think Humphreys is set to die a second time. I think everyone's pretty clear on that. I do think it cuts somewhat along these sort of judicial philosophy notes around the view of unitary executive and the role of the president. But I'll also just note that we have a lack of diversity on the court in another really important respect that Steve alluded to earlier, which is 7 out of 9 members of this court have worked in the executive branch. We used to just have a lot more variety of experience. And I don't even mean like specific work experience. I just mean the types of people who could be nominated to the Supreme Court used to be really different and much wider aperture than what we have now. We've really professionalized the court, which is why so many of them have worked in the executive branch. And, John Roberts was there during Iran-Contra. Gorsuch drafted a memo protecting executive branch officials from war crime prosecutions in the wake of Hamdi Hamdan type cases. Brett Kavanaugh, obviously, was staff secretary. So they have this one very specific type of experience about the need for strong executive power. Now, that being said, we are starting to see some very, very interesting pieces from some conservative law professors like Caleb Nelson saying the originalist view of the executive power is not the unitary executive. He just published this. Is it coming too late to get to the court in time for the December argument? I don't think so. I think he did it just in time. And that could be really interesting as they grapple with their executive branch experience versus their judicial philosophies of originalism and that sort of the founder's understanding of the powers of the president.
So I think it's really revealing that the Kavanaugh quote Sarah read from is a series of policy arguments for why the president should be able to directly control heads of agencies and not actually a constitutional argument. Seems like there are two big problems with the embrace of the unitary executive theory that the court has already undertaken, and that I agree with Sarah, it's likely to undertake in the Slaughter case.
And to be clear, wait, real quick, Steve, if I can just say, this was not an opinion. This is a law review article where he was intentionally making policy arguments. I just didn't make it clear that this wasn't a judicial opinion he was making.
Okay, but like it's still, listeners. I still think it gives up the ghost that the principal objections to independent agencies and to the president's inability to fire everyone at will really are historically policy arguments, not textual arguments. I mean, if we go all the way back to the founding, let's just take the office of Attorney General. Kind of an important officer when it comes to enforcing the laws. In the original draft of the Judiciary Act of 1789, which, a bunch of folks who wrote the Constitution were involved in writing, in the version that passed out of the Senate, the power to appoint the Attorney General, this critical executive officer, was given to the Supreme Court. Right? And, the ultimate version of the Judiciary Act actually uses passive voice to refer to how the Attorney General is going to be appointed, in contrast to the secretaries of the then departments of the Treasury, Foreign Affairs, and War, which were to be by the president. So the history has always been much, much more equivocal. This is part of Caleb's point in his article. And, if the justices were ever to deign to read left of center law professors, they'd find a whole bunch of that in their scholarship as well. The other piece of this is, Sarah alluded to the cryptic line in the court's very brief order earlier this term in the Wilcox case, where the court suggested that it would carve the Federal Reserve out from any embrace of the full unitary executive theory. So first of all, then it's not a theory, right? A theory of uniform, unilateral, unitary power that has exceptions for individual cases is not a theory about uniform unitary power. It's a theory about sort of presumptions that could be overcome. And it could be overcome for the Fed. Why can't it be overcome for the Merit Systems Protection Board, an agency that exists for the sole purpose of adjudicating employment and whistleblower-related claims within the executive branch? That agency wouldn't be worth very much if it was completely subject to the political whims of the White House. And so I think part of the problem here is that the result in Slaughter is overdetermined. The court is going to overturn Humphrey's executor. The court is going to say, of course, the Fed is different. And all that's going to do is reinforce the problem, which is that There's no historical consensus that supports the unitary executive theory as a clear and undivided line. Indeed, Humphrey's executor is inconsistent with it. Right? The arguments that you hear the most often about why the unitary executive theory is important are policy arguments, not constitutional ones. And let me just say last, one does not need to look much past the front page of the newspaper every day these days to see the dangers of a president who can do everything with every single apparatus of the of the federal government for his own personal political gain. I would think now more than ever, we actually might think the idea of a modicum of independence in some parts of the executive branch is a good thing. But even if you don't, the question about the second question presented is really important, because even if we accept as a fait accompli that the court is going to overrule Humphrey's executor, that just gets you agency heads. The second question gets you every officer of the United States. And the second question is whether federal courts can prevent or can provide as a remedy reinstatement of unlawful removals of officers, or whether the only remedy in these cases is back pay. If the Supreme Court were to hold, stunningly in my view, that officers who are wrongly removed by the president have only the remedy of back pay, then all of a sudden it's not just the unitary executive, it is the unitary executive run amok. It is Congress can't even impose any requirements, not just on principal officers, not just on heads of agencies, but on anyone exercising any meaningful power on behalf of the United States. That would be so much broader, bigger, and less constitutionally driven of a holding than just overruling Humphrey's executor with a, as Justice Kagan put it, bespoke Federal Reserve exception.
A couple additions to this. One, I totally agree that the second question on exactly what the remedy for the removal is like the super interesting part for the nerds. Two, I do want to push back on a couple other points. Though, one, in that same law review article, the end of the paragraph that I didn't finish reading it from now Justice Kavanaugh is, in short, the president is vested with the executive power in the Constitution, and yet actually exercises a relatively small slice of that power in certain critical areas of domestic policy. So I just want to be clear, it is a constitutional originalist sort of understanding, or separation of powers understanding, if you will, of why those independent agencies don't work, because they don't really exist anywhere if the president doesn't have the ability to actually execute the laws that he was elected to execute. On the Federal Reserve, there is an argument for why the Federal Reserve is different. I think it would make for a bit of a messy decision by the Supreme Court. But when it comes to monetary policy, the argument is that it doesn't run afoul of CELA law, that the Federal Reserve is doing something more like the Second Bank of the United States, going all the way back to Chief Justice John Marshall, and that when it's doing monetary policy, it is not exercising executive power like, for instance, the Federal Trade Commission is now. The problem with that is that, yes, that's how the Federal Reserve started. Yes, it is the most important thing that it does, but it does now have some executive power to investigate, et cetera. So I think you'd have to see them say the monetary policy side can stay insulated per Congress, per the Second Bank of the United States, but all that other stuff that it has started doing that looks more like executive power, the investigations and sanctioning, that's gone, or they're not insulated. Again, it makes for a messy outcome, but I think that is the rejoinder to what Steve was arguing about.
Thank you both for that. And now it's time for closing thoughts. Sarah, let's start with you. Are there any other cases that we haven't discussed that you think are particularly important? What are you closely watching for in this term?
So if the second part of the last term, and maybe the last several terms in total, have been about the rise of the interim/emergency docket, I think this term that we're about to start is more about the apotheosis of the interim docket. We're now seeing cases move from the interim docket into being argued and briefed more fully, which is what a lot of the critics, correctly, I think, in a lot of cases, were pointing out was a real problem with the interim docket, that they weren't being fully briefed, that they weren't giving real, thoughtful, long decisions and opinions on this. And so we're seeing the court maybe experiment is the wrong word, but this is sort of the first time that the merits docket is getting pushed aside so that those interim questions can be fully resolved and fully briefed. I think that we'll see more of it, but it does lead to that interim upon the interim upon the interim problem where, because, for instance, the Federal Trade Commission argument is set for December, there still had to be some status quo then in the meantime of that. So I don't think it resolves every criticism, but maybe it's just going to be a 3-layer cake. And that's going to be the new normal. It will be fascinating this year because we have so many culture war-ish cases on things like free speech and conversion therapy, on religious liberty for a Rastafarian whose hair was shaved by prison officials, and transgender participation in women's sports. And I just predict those aren't the things we're going to be talking about at the end. It's going to be about separation of powers. And boy, if you had bet me a shiny nickel 20 years ago that the biggest, most contentious things that are being followed by, Sunday shows and cable news were going to be separation of powers cases at the Supreme Court, I'd be 5 cents poorer.
Steve, what other cases that we haven't discussed do you think are especially impactful? And do you agree or disagree with the idea that the separation of powers will be the central theme of this term?
Well, I think first of all, it's worth stressing that, that a handful of cases that started as emergency applications are now coming back on the merits doesn't make up for the fact that we still have an unprecedented number of emergency applications that are being used to affect millions of migrants, hundreds of thousands of Americans, whether it's with regard to their federal jobs, whether it's regard to their ability to drive around Los Angeles without being worried about being pulled over by ICE because they look a particular way or because they speak a particular language or because they work a particular job. Those cases are not on the merits docket. And those are cases where the Supreme Court's interventions are continuing to have massive effects that, we really ought to be talking about. I do think Sarah is right in one respect, which is to focus on how much this term by the end really is probably going to be about the separation of powers, even in the non-Trump cases. So, we haven't talked at all about the Louisiana redistricting cases, where I think it's very likely that the court is going to take yet another tool away from Congress when it comes to the ability of Congress to remedy racial discrimination in the drawing of congressional districts. That's a huge decision. In any other term, we would have spent the first half of this hour talking about it. I'm bringing it up at the end just so that no one can say we didn't mention it once, right? But it really does all seem to pale in comparison because, whatever you think of the term constitutional crisis, we are certainly in an institutional crisis in this country, one in which Congress is doing absolutely nothing, not just from a regulatory perspective, but from an interbranch accountability perspective. And I think the real question for the Supreme Court as we look ahead to the October 2025 term is whether that matters, and whether the court sees itself as a bulwark against the assumption of all power by an executive branch and by a president who has not been shy about exercising and claiming powers that his predecessors would never have thought to exercise or claim, or whether the Supreme Court is going to enable more of that behavior, even if it doesn't affirmatively uphold it. And so the last thing I'll say is, I think one of the real themes of the term to come is the increasingly tempestuous relationship between the Supreme Court and the lower federal courts. We are seeing more and more lower federal court judges from across the ideological spectrum speaking out publicly and certainly privately in criticism, not of the Supreme Court's rulings, but of the court's behavior, criticizing Justice Gorsuch's concurring opinion in the NIH case in August, which accused district courts of defying rulings on the emergency docket that had no explanation whatsoever. And so I think this is a really, really important, maybe even a bellwether term for the Supreme Court as an institution, not just in how it understands the role of the federal judiciary writ large, vis-a-vis an increasingly law-curious or authoritarianism-curious president, but how also to understand its relationship with the other courts of the United States. And I don't know how it's going to end, but I think that there's no question that a year from now, it will have been a very, 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 very big deal And I hope it's one that we don't look back on with regret.
Hey, this is Griffin, following up after the conversation to share my thanks to Sarah Isgur and Stephen Vladeck for joining We the People this week.
This episode was produced by Bill Pollack and Griffin Richie. It was engineered by Bill Pollack. Research was provided by Griffin Richie, Anna Salvatore, Praise Sullivan, and Tristan Worsham. Friends, I'm thrilled to be launching my new book in October. It's called The Pursuit of Liberty, How Hamilton versus Jefferson Ignited the Lasting Battle Over Power in America. Please pre-order online, and if you'd like a signed bookplate, please let me know. And always remember that the National Constitution Center is a private nonprofit. We rely on your generosity, passion, and engagement for all of our programming. Please consider donating at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Jeffrey Rosen.